It's been baffling and quite embarrassing how issues relating to this bill have been played out both inside and outside this House. And I would also want to stress the point that if there is such a sense of urgency to reform the judicial appointment system, why then has it only taken place after the Taoiseach and his government have appointed the former Attorney General to the Court of Appeals? Surely this bill has been much made that it's about taking the politics out of appointments of judges. But the reason this is purely politics that this bill is coming forward, and to appease the junior partners in the coalition government is the reason that it's coming forward now and coming forward with such a sense of urgency. Fianna Fáil had a similar bill in committee, which the government killed off by the use of the money message because it wasn't in their interest, again for purely political reasons, and because the bill could have stolen Shane Ross's thunder and his reason for being. Surely, if this government was mature and proper, the government would have joined with Fianna Fáil and allowed Shane Ross and Deputy O'Callaghan to actually move this bill through committee stage, and we could have reached this point far quicker without the sense of urgency and without any opposition here in the Dáil for it to take place. The Dáil has been unfairly blamed for the slow progress of bills going through. However, Fine Gael is the one obstructing the process of bills, while at the same time fast-tracking this particular one we are debating today. It just shows that it's not new politics at its fault here, but the inability of the government to maintain the integrity of the legislative process because it hasn't the courage to engage in democratic debate. My colleague, Deputy Catherine Connolly, in her contribution to this bill, rightly said that all of this is an illusion that the government is serious about reform. An illusion that politics will finally be taken out of the equation in judicial appointments. An illusion that this reform will adequately filter down to address the grave inequalities and elitism plaguing the rest of the judicial system. Even if this bill gets through, and it's quite possible that it mightn't, that possibly the Justice Committee will use its procedures to stall the bill and not get it through before the summer recess, the government still retains the power to appoint whoever it feels like as a judge. In fact, the government could essentially bypass a new Judicial Appointments Commission if they don't like the 3 recommended names put forward by the Commission, because this power is protected within the Constitution. It would require a referendum before this is ever changed, and since we already have a Citizens' Assembly tasked with debating the need for certain other referenda, we've missed that boat. How can we take politics out of the process when the Attorney General, who herself is a political appointment, sits on the new Commission, and where no rationale will be given for the recommendation of candidates that are included in the text of this bill? This bill is becoming more and more reflective of the farcical political process at play between the Coalition and Fianna Fáil. The bill does provide for the Commission to be made up of a layperson and a majority of lay members. And I note the commentary focusing on lay people in the appointments process and what is essentially a fear some seem to have of lay people in general. It's as if we are terrified of anyone outside the inner circle of the elites having a say in what is in essence an institution which upholds the Constitution of the People's Republic. The people themselves are the final arbitrators in relation to the Constitution, so surely the people should be able to have a say in who actually interprets that Constitution and implements it. I listened with amusement earlier in the week to the retired judges coming on the radio talking about how you couldn't have lay people putting forward names and being in a majority on this new commission putting forward names to the judges, because the retired judges and the serving judges all know all the people, all the applicants, so therefore they're the best placed to actually make a recommendation. But yet I don't think the Judicial Appointments Commission has ever made a recommendation. We hear that they put forward 7 names, 8 names, 10 names, and in some cases maybe even up as far as 20 names. So that shows that the existing system is incapable of offending any of its own elite members, because they don't want to pick one over the other to put them forward as a person that's best placed for the job. And I think the process of putting forward 3 names still allows a political process to pick the person that they like and the person that they want to bestow patronage on. The retired judges, when they were talking on the radio, were going on about how no other system would this be expected to happen, where people who weren't intimately involved in the actual job itself would be putting forward names. I can't think of any other job application process in this country, and probably indeed in the world, where 3 people or 7 people or 10 people are put forward and saying pick one of them, any one of them is good enough. Any interview process, any application process comes out with a person who is the best qualified for the job at that particular time. That's no slight on anybody else that has applied for the job. It just means at that particular time they weren't the best qualified person. Every single ordinary mortal in the country has to go through that process in order to get a job. But yet it's not right to expect judges or the legal profession to actually go through that process. I think that's what's wrong. I think actually this Commission should put forward one name and should say, of all the candidates that we have got, this is the person that we believe is the most suitable for this position at this particular time, and put it up to the political process and let the political process then appoint the person that's recommended by the Commission itself. If ordinary citizens are trusted as jurors to make really important decisions in deciding the guilt or innocence, and maybe destruction or not, of the lives of people who are before the courts, and nobody questions the jury system, why are we questioning ordinary citizens' roles now? The Medical Council has a lay majority, as do other regulatory bodies for different sectors. And I agree with the sentiment that no regulatory body should be self-regulating or self-appointing. In saying that, the Judicial Council Bill, which was only published in the last few weeks, should be established and in place, and the Judicial Council should be in place, I believe, before this bill, as it will provide a mechanism for the investigation of complaints against judges and will enable the preparation of draft guidelines concerning judicial conduct and ethics. And surely that should be part of the process of deciding whether a candidate is suitable for a particular position, a particular job. And if you have that code of conduct and you have those ethics in place, then you can compare the proposed candidates in relation to that. Surely this culture needs to be established before we bring in a new process to appoint judges. The Commission must also be accountable and take heed of the ethical guidelines as set out by the Judicial Council, as I said. There's clearly no coordinated or concerted effort here to bring reform in the judiciary, despite this issue dominating Shane Ross's political career. Ultimately, we need to focus on the diversity of the sector, not just between lay and professionals, but within the pool of professionals themselves. We need to foster diversity within the law profession by encouraging people of all classes, gender and ethnicity to take up the law. This will mean reforming how people can enter law school and significantly reducing costs of getting a law qualification, which are prohibitive. The nepotistic and patronage culture inherent in both the Law Society and the Bar Council are further prohibitive for those already practising, particularly for women in the sector. Unfortunately, the bill as it stands won't address this issue, particularly as Section 7 of the Heads of Bill has been taken out of the current text of this bill. This section would have made sure that the Public Appointments Service and the Commission itself must have due regard to the gender balance and diversity, as well as merit in the decisions it makes for judicial appointments. Right down through our system, we insist on gender balance and gender equality in terms of appointments, all through the local authority system and everything else, but yet we're not going to insist on it here. Fostering diversity starts at the very beginning in our society. I have tried on 2 occasions to pass an Economic, Social and Cultural Rights Bill in the Dáil, which would enshrine the rights to housing, health and education in our Constitution. And this would have been a basis by which we could foster equality among all our citizens, so that class, gender, ethnicity are no longer barriers to employment or even to accessing a justice system, such as the provisions to free legal aid. And that's what would be important by changing our society so that we can get more diversity into the legal profession and subsequently into the judicial profession. On a final note, I think it can't go unsaid that the cost of access to the justice system is still an outstanding issue which the government could care less about. There doesn't seem to be a sense of urgency to address this, yet if it is serious about the reform, the government would have started with more genuine measures, for example increasing access to free legal aid for people who cannot afford to access the justice system, rather than playing a political game to appease your coalition partners.
Má ag bag muid réana sé an teachta Billy Kelleher.